Well, thank you for those very kind words of introduction. And let me say how really honoured I am to be invited to give this MacDermott lecture, and somewhat intimidated, I must say, firstly by the audience, so many prominent people with enormous skill in the room, secondly by the eminence of the previous lecturers, and thirdly by the obvious weight of the lectures themselves. The subjects that they've chosen to lecture on seem to be enormously important. I'm also slightly worried that by choosing to talk about private law, I may not be completely fulfilling the terms which the Pro-Vice-Chancellor read out from the original purposes of the lecture laid down by Lord MacDermott. Because private law is, after all, a technical subject, and very often we are trying to solve rather technical problems. But it does seem to me that if we're talking about private law, we need, just as much as with public law, to examine what it is that we're trying to do. When we're trying to solve technical problems, are we implicitly adopting policies which are actually acceptable or which are consistent with our underlying values? And if we fail to raise those questions, we are not doing a proper job. I think of myself rather as a legal plumber than a legal architect, and my constant worry is that I will design a beautiful set of pipework which has the effect of discharging the dirty bathwater onto the guests as they arrive at the front door. So I'm very much in your hands, because I would like to hear back from you, and I hope there will be the opportunity at the end for some discussion as to whether actually you think what we've been trying to do with the Common European Sales Law is indeed an acceptable way for the law to proceed. But let me try and explain what I'm actually going to talk about, because I'm going to talk about the Common European Sales Law proposal. It was a proposal made by the European Commission in 2011, a proposal for a regulation. A proposal which was adopted very enthusiastically in February 2012 by the European Parliament, subject to a number of amendments, many of them technical amendments, actually taken in large part from a very helpful statement or critique of the proposal prepared by the European Law Institute, but also with a political restriction, and they were quite overt about saying this is just to make it easier to get through, that it should be limited to distance contracts only. That was partly because the Council, the European Council, was dragging its feet. Member states, in many cases, were rather reluctant about this proposal. And indeed, in November 5 member states actually wrote to the commissioner responsible asking that the whole proposal be dropped. And you may know that when Mr. Juncker produced his list of proposed legislation that should not be carried forward because it didn't seem to be getting anywhere, the Common European Sales Law was one of the items on the list. However, with this item, Mr. Juncker said that instead he would produce a modified proposal in order, quote, to fully unleash the potential of e-commerce in the digital single market. So what I want to do today is to talk a little bit about how in general we tackle the problem of differences between the laws of contract across the European Union, to say something about the nature of the proposed Common European Sales Law and the general case for it, and indeed the objections to it. But then to talk about how we might change the proposal in the light of making something which is suitable primarily for the digital market. And I think there are a number of issues which can bear re-examination. But I want to end up by comparing the underlying policies and values which I think are enshrined in the Common European Sales Law with that of contract law in the UK, because there are significant differences and we have to think about whether they are acceptable or not. Now, we all know that contract law is a matter for each member state. But of course, there has been a certain amount of harmonization. Most obviously, we have regulations which actually give us the same set of rules on private international law, but in particular the Rome I and Rome II regulations which deal with what law should apply in a cross-border dispute, and the Brussels I regulation which deals with the question of directives. But when we're thinking about substantive law, we also have quite a number of directives which have a harmonizing effect. principally, of course, in the consumer area. And although some of them are regulatory, many of them give consumers individual rights. In particular, what used to be called the doorstep and distance selling directives, now replaced by the Consumer Rights Directive, make sure that member states have to give consumers the right to get certain information before they enter a distance or what's now called an off-premises contract, and also have the right to withdraw from it. We have the Unfair Terms Directive, and we have the Directive on Consumer Sales, which makes sure that consumers have basic rights, the ones that are enshrined in our Sale of Goods Act, and also certain remedies. But underlying those consumer rules, we have, of course, the general law of contract, and that is not harmonized. But there have been a number of attempts to try to discover the underlying principles which perhaps we share or perhaps we don't share across Europe. Sally mentioned the Commission on European Contract Law led by Professor Landau, in which I played a small part, I'm not going to exaggerate it, which in 2000 produced the Principles of European Contract Law. And if you're familiar with the American restatement, but not with the Principles of European Contract Law, you'll find that in form they're basically similar. The principles consist of a series of articles with a commentary about how it's all supposed to fit together and comparative notes, comparing what's in the principles to the laws in all the different member states. And then that sort of method was expanded very greatly by the so-called study group on the European Civil Code led by Professor von Bahr, which tried to do the same thing not only for general contract law, but for special contracts, and also for tort, unjust enrichment, and indeed subjects of property law. And then lastly, I'd mention the so-called ACI group, led by Professor Schulte-Noeke, which was an attempt to derive some general principle from the very fragmented directives that we actually have. Slightly an exercise of imagination, let's call it, but nonetheless they tried. And all these groups used essentially the same comparative method. That is, that they tried to explore to what extent there are real similarities between the laws and to what extent there are differences between them by the so-called functional approach. That involves stripping away all the differences in terminology, all the differences in concepts, and trying to work out how do the various systems actually solve particular concrete cases, and then stating the results in the form of a series of principles. Hopefully, largely shared principles, but where there are differences, you have to come up with either what seems to be the best rule or at least a compromise that everyone can live with, so that you produce at the end of the day a workable European law. That was the idea, at any rate. Well, what's the purpose of these restatements? Well, of course, like many things, they serve multiple purposes. And there's no doubt at all that in some people's minds, this is a political exercise. This is about furthering the project of European integration. Think about the German Civil Code and how the German Civil Code was considered to be a major cultural asset in producing a unified Germany in the late 19th, early 20th century, out of a series of separate states that existed before. It was seen as building a common culture. And there's no doubt about it that some people, including Professor Landau, would like to see a single or at least a fully harmonized single law of contract across Europe. And there are people, including Professor von Bahr, who would like to see each of our national laws replaced by a single European civil code. Now, before we go any further, I would like to say I do not share either of those aims. And I think actually most people who were involved in those groups did not share those aims at all. Even if they thought, well, maybe one day, which I would hate to see, but even if they thought maybe one day, their aims were much more modest, to try to make it easier to deal with cross-border contracting. And that's certainly the position of the European Commission. In 2001, the European Commission produced a so-called Communication on European Contract Law, which was essentially a consultation document, and it asked people, do the differences between the laws of contract make it more costly to make contracts across borders? And of course, what the Commission is interested in is bolstering the internal market. They want to see more cross-border contracting because that hopefully will produce more choice, more competition, and therefore lower prices. So it's a political but economic aim on the part of the Commission. Now, of course, the idea of producing neutral rules for international transactions is nothing new. And although we've never subscribed to it, the International Convention on Sale of Goods, the Vienna Convention of 1980, the CISG as it's often called, has been adopted by very many states around the world. So that if, for example, a French seller is dealing with a German buyer, unless they opt out of it, they will end up contracting on the terms of the CISG because it forms part of both French and German law and will apply to cross-border contracts unless the parties opt out. But there are also international soft law things which are much more like the restatement. The UNIDROIT principles for international commercial contracts is the prime example, which are not recognized as law which can be applied by courts, but which could be used by arbitrators, for example, for solving international disputes. But we're dealing with things which are specifically European. And I think we ought to ask, well, who is actually affected by this problem of differences between the laws? And the response to the 2001 consultation paper, the Commission said, was, yes, there is evidence that differences between the laws hinders the internal market. Now, I have to say, I'm not particularly convinced by the evidence that they received. I don't know that it really proved the case. But I think simple intuition tells us that actually it must add to the cost of doing business if you've got to deal with more than one law of contract. Let's suppose that you're a seller in the United Kingdom wanting to sell to a buyer in Germany. And the buyer says, we would like to use German law. You would have to know, well, will my standard terms of contract work under German law? And that's going to take time and money to discover. So intuition is that the differences between legal systems, to some extent, must add to the costs. But I don't think that it's such a problem for larger firms, for a number of reasons. First of all, if a larger firm is actually thinking about selling a great deal in Germany, it's very likely to open a German subsidiary, which of course will then use German law. In other words, it may not be making cross-border contracts. But secondly, even if it is, a larger firm is likely to be more sophisticated in the sense of having in-house lawyers or experienced business people who are used to cross-border contracts and will probably know more or less what they are doing. Or even if they don't, because they are making larger contracts, or at least larger runs of similar contracts, they will find it relatively cheaper compared to the cost or value of the contract to take legal advice. And lastly, larger firms, quite simply, can take bigger risks. It's smaller firms, small and medium-sized enterprises, as the European Commission likes to call them, who are much more likely to be affected. Now, of course, some SMEs do already trade across borders, but we suspect that it's SMEs who are most likely to be put off, to be frightened of cross-border contracting because of the differences between the legal systems. But when you're talking about sales to consumers, everybody is affected by a problem which is caused by the Rome I Convention. With a consumer contract, the parties can, of course, choose the applicable law, even for a consumer contract. So if you have a German company trying to sell to consumers in England, they will probably say, we want a contract subject to German law. But under Article 6.2 of the Rome Regulation, it's provided that if a business trades in a consumer's member state or directs its activities to that member state, and the consumer enters into a contract with the business, even though the contract may be on the law of the business's residence, the consumer is entitled to the protection of the mandatory rules of their habitual residence. Now, that's good for the consumer, but think about it from the business's point of view. That would mean that businesses that are trying to sell across borders should know about the consumer law in every country that they're trying to sell into. And if you think about a little business trying to set up an internet shop where they're trying to use the internet to sell right across Europe, that might mean knowing about 30 or more different laws of contract across Europe and different sets of consumer protection. So it's quite a challenge. Now, what has the Commission done about this? Well, as you know, consumer protection is not itself a treaty aim. It's not something on which you can base legislation. It all has to be based on the internal market. But there was a change in approach. Up until roughly 2003, the way the Commission seemed to be thinking was the way to get the internal market going is to give consumers confidence by making sure that wherever they buy in the community, they have a minimum set of rights, so that they will always have basic protection. So, for example, they will always have adequate remedies if the goods are not up to quality. They will always be able to challenge unfair terms, and if they make a distance contract, they will always have the right to withdraw. But those were simply minimum rights which had to be given to each consumer. But after 2003, there was a change. The Commission realized that perhaps the way forward was not to worry so much about the consumer as about the business. It's really to try to encourage businesses to offer to consumers in other countries. And that means trying to reduce the barriers that are perceived by businesses. Well, how do you go about it? Well, of course, one way is simply to try to make the existing consumer legislation, the so-called consumer acquis, easier. And the Commission's first act was to say, well, what we want is a kind of legislator's toolbox called the Common Frame of Reference, which will provide us with principles, definitions, and model rules which we can use to improve the consumer acquis. And what they did was to get all those groups that I've mentioned to form together into a network. The European Commission doesn't like dealing with anything smaller than a huge network, but they've asked us to form a network to produce something called the Draft Common Frame of Reference, which was delivered to the Commission and published in 2009. But actually, what the Commission was interested in was not improving the consumer acquis to give consumers more rights. It was about changing the consumer acquis to make it easier for businesses. How? By switching from a system which said consumers in every country must be given the same minimum set of rights, to saying they must be given the same set of rights. In other words, to switch from minimum to full harmonization. Now, if you think about that, that would mean that in those jurisdictions where consumers have better protection than the minimum required by the EU, that consumer protection would have to be reduced. And not surprisingly, when the Commission proposed that for the first draft of the Consumer Rights Directive in 2008, it was a political failure, because member states said, why should we reduce our consumer protection, even for domestic transactions, just to make it easier for people to sell across borders? No way. So in the end, they had to accept a much narrower version of the Consumer Rights Directive that basically only deals with distance and off-premises contracts. But by then, the Commission had its alternative approach, the Common European Sales Law. And the idea is simply, rather than change the law in each country, to create a parallel universe, an alternative law which can be used for cross-border contracts. And it would work rather like the Vienna Convention does for commercial sales. Into each member state's law would be inserted, by regulation, this alternative regime, which the parties could use, if they wish to do so, for cross-border contracts. And if they choose to use it, it will be those rules which govern rather than the domestic rules. In other words, it will displace the domestic rules, at least within the scope of application of the Common European Sales Law. So it would work rather like the CISG, except that the CISG is an opt-out system. The CESL, the parties would actually have to opt in. And what everybody envisages, for example, with a consumer contract, is that the trader would have on its website, do you agree to use the Common European Sales Law? And probably there will be a nifty little blue thing you click on, which is 12 gold stars, and you click on that to show that you accept the Common European Sales Law, the so-called blue button. It could be used for sales contracts and also for digital downloads, where you download something from the internet, but there's no CD-ROM or memory stick or anything like that. So there are no goods, but nonetheless, you're actually buying digital content. And also for related services like installation and maintenance. And it could be used both for business-to-consumer contracts and business-to-business contracts, at least when one party is an SME. They limited it to that because they thought that that was the only situation where they could show there was a real problem. So that was the only case where they had a legal base, but they carefully said in Article 13 of the proposed regulation that member states would be free to extend the usability of the Common European Sales Law to any business if they wish to do so. And essentially, if you look at the list, you can see that the Common European Sales Law covers most of the standard stuff in the law of contract, including things like pre-contractual information and withdrawal rights in consumer contracts, but also including all the seller's obligations, the buyer's obligations, and so on. So it's quite comprehensive. And it deals with the Rome I problem, because it doesn't alter the domestic law in each member state. What it does is, if the parties choose to use the Common European Sales Law, it, as it were, pushes the domestic law on one side. It displaces it and replaces the mandatory rules of the domestic law with the mandatory rules of the Common European Sales Law. And that rather niftily solves the Rome I problem, because the consumer is still entitled to the protection of the law of their habitual residence. But if they choose to use the Common European Sales Law, it will be the Common European Sales Law bit of their domestic law which will apply, rather than the normal domestic law. And I think that works perfectly well. There are some colleagues who don't think it does in conflict of law terms, but I can't actually understand their arguments. But whatever happens, the idea is that there would be in this instrument a high level of consumer protection which goes well beyond the minimum required by the existing consumer acquis. So it seems to me that there are trade-offs to be made. Think about the trader's position. When a trader is selling to a consumer who is in a state which has a relatively low level of consumer protection, just the European minimum, if they offer to use the CECL, they would have to give the consumer more rights. That would be a downer for the trader, as it were, but the upside is they would get to use a single system for all their sales. And of course, they may be able to persuade their member state to allow the use of it for domestic sales as well. That's allowed for in Article 13. For consumers, what's the trade-off? Well, if you live in a state with relatively low protection, you'd actually be better off using the CECL because it has a high level of protection. So by pushing that blue button, you'd be increasing your rights. If you live, however, in a state which has a higher level of consumer protection, and certain aspects in certain states do give a higher level than the CECL, then you would get slightly lower protection if you were to choose the CECL. But if the system works, if this really encourages more businesses to sell across borders, you get the benefit of better choice and more competitive prices. That's the hope. What about business-to-business contracts? Well, the first question is, does the law really matter at all in business-to-business contracts? Sally kindly referred to the piece that we did years ago, looking at the contracts made between engineering manufacturers, when we discovered, rather to our surprise, that actually the law doesn't seem to matter very much. I remember the first interview with the sales director of a major firm just outside Bristol, and he said, right, what's your first question? And my first question was, when you sue somebody, does the rule in Hadley and Baxendale give you adequate damages? And he said, wait a minute, I think we need to stop. I have never sued anybody. I never intend to sue anybody. Hadn't you better redesign your questionnaire? And we discovered that actually they don't use litigation or arbitration to settle their disputes. They were settling them all informally, relying on social and particularly economic pressures. if I don't deliver, I won't get any more business from you. So I'm going to deliver, aren't I? That's the sort of the reality of the pressure. And they didn't go in for much contract planning, at least for small transactions. They knew perfectly well that they were busy swapping standard forms, and they realized that the battle of the forms did not produce a contract. And we said, you know there's no contract. They say, yeah, we know that. We've been on contract law courses too. But we don't give a toss, because actually we don't need to use the law. Now, that's led some people to say contract law doesn't matter, but I don't think it does show that. First of all, there's a lot of variation between sectors. Look at the commodity trades. They're planning their contracts in great detail, and they're suing each other with monotonous regularity. Bunge and Trade-X and Bunge. It happens all the time. But secondly, even our engineering manufacturers were planning their contracts in considerable detail when, particularly, they hadn't dealt with the other party before and felt they didn't have the same degree of trust that they would have with people that they knew. In other words, law is a useful substitute when there is no trust. And it may be that actually there isn't going to be a problem and that the barriers that SMEs fear are more psychological than they are real. But nonetheless, I do think that SMEs are likely to think the law is important, and therefore they need to be our principal target. But it's not just a question for SMEs about differences between the laws. It's also a problem, again, about their sophistication and the fact they're not likely to take legal advice. Take a very simple example. An SME may well be confronted with the other party's standard terms. Is an SME, a little firm, are they actually going to read those terms? If they do read them, are they going to understand them, particularly if they're in German? Well, I rather doubt it. And it's quite clear that many SMEs are not savvy enough when they're negotiating the contract to ask everything that they should do or to ask all the right questions. And they quite often don't anticipate the tricks that the other party might get up to. Now, the only way to protect SMEs against that is to provide a modicum of protection for SMEs when contracting. And that's not something completely new. In 2005, we recommended that essentially the Unfair Terms Directive protection should be extended to protect small business contracts. It's the same sort of idea. Now, what sort of protection do you find in the Common European Sales Law? Well, first of all, we find controls over unfair terms if they were part of a non-negotiated set of the terms, assuming that they weren't core terms, which are, of course, exempt. We find relief available for unilateral mistake and a duty of disclosure on the other party in extreme cases. And there's even a limited provision providing a duty of good faith and fair dealing, though its primary purpose would actually be to do what we would achieve by means of doctrines of estoppel and waiver, preventing me from relying on a clause when I'd indicated that I wouldn't, but also might be used when I appear to be using the clause in a slightly dishonest way, which really amounts to abuse of right. So it's quite a limited provision, but it's there. So if the CSAW is so wonderful, why is it being opposed? Well, I think there are a number of reasons. First of all, the consumers' associations, many of them are against it, for two reasons. The first reason, they say, is that consumers will be confused by being offered a choice of English domestic law or the Common European Sales Law. Well, I don't believe that for a moment. First of all, they won't get the choice. They'll have to click the boo button if they want the goods, so the choice will never arise. But secondly, I just don't believe that consumers know anything about the law. And if they did try to find out what the existing situation is, I would find it far harder to explain that if you buy from a German website, you're probably going to be subject to a mixture of German and English law. That's readily comprehensible to every consumer. So I just don't believe that objection. The other objection is more serious. What they're worried about is that at the last moment, in an attempt to get this through, the Commission may duck and reduce the consumer protection to make this more business-friendly. And if I thought that would happen, then I too would be against the Common European Sales Law. But I just don't think it will happen, because I think the Commission realises this is only going to work if the Common European Sales Law contains a high level of consumer protection. What about business-to-business contracts? Well, there the argument always seems to be this is just the thin end of the wedge. I've heard the Common European Sales Law described as a Trojan horse. It's an attempt to get to a European civil code without appearing to do so. One day we'll have a purely optional system, and then next month all the ministers will go to Brussels and be unable to agree on anything, so that to come home with not completely empty-handed, they'll say, okay, let's have a common European sales law unified across and get rid of our national differences. Well, I just don't believe it, frankly, but I would certainly oppose it if I thought that was going to happen. But let me talk now for a moment about the opportunities presented by the possibility that we're going to have a new instrument, a new proposal aimed at the digital single market. Because it seems to me that this, first of all, may appear less threatening, particularly less threatening if we can slim it down and simplify it. But it also seems to me that if we focus on digital contracts, and in particular web-based trading, contracts made over the internet, we may be able to adapt the proposal to reflect the needs of the parties more closely, and actually, in particular, to reduce the differences between the rules for business-to-business contracts and the rules for business-to-consumer contracts. Well, first of all, what do we mean by the digital single market? Well, I haven't been able to discover yet what the Commission means. Because if you look at Mr. Juncker's outpourings on when every time he mentions the digital single market, he talks about web trading, but he also talks about email, telephone, text messages, and indeed electronic data interchange, a sort of situation where as Tesco sells stock, their computer automatically orders more stock from their suppliers. No human interaction involved. It's all done by computers at either end. Obviously, the main focus is going to be web trading. And web trading is a little bit different to the others, because with web trading, it's a form of mass communication. There's not going to be, or unlikely to be, any form of individual communication between the parties. So there's not much chance for questions or negotiations, and we need to take that into account. Now, I said before that the European Parliament, for political reasons, to try to make the proposal seem less threatening, suggested it should be limited to distance contracts. And that's defined in such a way that if the parties ever meet, it's not a distance contract, and therefore the CECL couldn't be used. Well, maybe we could say the new version should be for website contracts only. But I would be against that for practical reasons, two of them. First of all, what happens if, by chance, the consumer telephones a supplier and they talk on the telephone? That, if you used a sort of distance contract-like definition, would mean this is no longer web-based trading. And if the CECL couldn't apply, suddenly the parties would find they were outside the scope of application. That a sort of case of accidental disqualification. I think that would be very confusing. But also, many traders run mixed systems. I'm sure I'm not the only person who's used websites where you can order online or they give you a telephone number. And the trader is not going to want to have to run two different laws of contract, one for the web-based trading and the other for the telephone orders. That would be crazy. We might be able to manage by saying, well, it must at least all be digital, so emails and telephones won't take you outside the scope, but actual postal communications would. But then I think about recent experiences that Jane, my wife, and I have had of booking things online, and we find that people are often sending us more information in the post. Well, again, we don't want to be disqualified from using the Common European Sales Law simply because we sent our customers something in the post. So what I would do is to say that this is particularly aimed at web trading, but I wouldn't limit it to that. Next question. Some people say, well, why don't we get rid of business-to-business contracts and concentrate just on consumer contracts? After all, with business-to-business contracts, the differences between the laws are less problematic. There were fewer mandatory rules. And of course, if if you follow my line and say that the Common European Sales Law should contain quite a lot of substantive protection for the parties, then it's more threatening to national law. So why don't we get rid of the business-to-business bit? Well, again, for purely practical reasons, I think that would be a mistake. First question, how on earth does the trader know who the customer is? When I order a new computer, how do they know whether I'm going to use it for doing chitty or exclusively for playing games when I can't take chitty any longer? Nobody's going to know. But in one case, I'd be buying for business purposes. In the other case, I'd be buying for private purposes. Now, you can probably operate a website which is only for businesses by making people prove that they're businesses before you give them an access code. But if you have a general website, it's virtually impossible to exclude business buyers. And I think it would be also very inconvenient to have separate regimes, separate legal regimes for business buyers and consumer buyers. And again, you get the risk of misidentification. But more than that, I think not to deal with business-to-business contracts in this digital single market would be a missed opportunity. Now, we all accept that even in an instrument like the CECL, which is aimed at SMEs, we need some protection for SMEs, but they need less protection than consumers do. Fewer mandatory rules. So, for example, we probably accept that in a business-to-business contract, the seller might be able to exclude its responsibility for fitness for purpose, or the buyer might be able to agree to have reduced remedies. For example, that the seller's liability in damages should be limited to a set amount, which is not allowed in a consumer contract. We might have a slightly less demanding test of what constitutes an unfair term in a business-to-business contract. But when we think about website and other digital sales, is it really right to distinguish as sharply as we do at the moment between business to business and business to consumer? Some of the legislation doesn't. The e-commerce directive, which, for example, requires anybody operating a website to indicate how you can correct mistakes, that applies whatever the nature of the contract. But the Consumer Rights Directive, which requires pre-contract information and gives people the right to withdraw, that only applies to consumer contracts. Well, why? The rationale for giving people a right to withdraw in distance contracts is usually stated to be, well, you can't see the goods until they've arrived. They may not turn out to be exactly what you wanted. So you should have the right to give them back, get your money back, or the right to withdraw your offer. Well, in practice, of course, a trader may not differentiate between consumer buyers and business buyers, may allow everybody to return the goods. Indeed, our engineering manufacturers, back in the 70s, were very happy to let their customers cancel orders, providing they did so before the goods had actually been shipped. But that means that either the business buyer, I'm sorry, I've used BB to indicate business buyer, means the business buyer must either check the trader's terms each time to check that this trader is giving a right of withdrawal, or must try to argue for one, or will have to rely on the trader's goodwill. But remember, they're often going to be dealing with a trader that they don't know. They can't count on that trader having goodwill. We just don't know. So it seems to me that business buyers should have a right to withdraw just like a consumer buyer. Now, it may not always be needed. If you're buying goods which you've bought many times before, you know exactly what you're getting. You don't need that right of withdrawal. But if you're never going to use it, it won't cost the trader anything to include it. And in any event, we could probably work out a system whereby the buyer who is a business and who is prepared to, as it were, swear that they are a business, can actually waive the right of rejection, perhaps in exchange for a slight discount on the price. And we can use the magic of the internet to make it very easy to do that. When you choose your delivery options, as you do when you shop on Amazon or whatever, we could have a pop-up box. Are you a business? If you are, give us your VAT number. Do you want to waive your right to withdraw? If so, you'll get 0.5% off the price or something. That could be done if necessary, but I doubt it's even necessary. And it also seems to me that these rules on pre-contract information should be extended to businesses. After all, business buyers have to be given a certain amount of information under general contract law. If I don't, for example, say that there will be a delivery charge payable, then I'm probably not going to be able to enforce it just as a matter of general contract law. But it seems to me there is no harm in making traders who are using the internet spell all this out. Okay, business buyers are better informed, they are more sophisticated, but there are still risks. When I, as a trader, am trying to sell you something, I will, of course, give you all the information which seems to make the goods look better. But what I may not tell you about are the drawbacks. Think about the provision in the Consumer Rights Directive that was inserted at the last moment, saying that traders who are selling digital content must inform the consumer about the relevant interoperability. Now, that's gobbledygook to me, but what I'm told it means, for example, is they must tell you if this software will run on a PC but not on a Mac, because otherwise you might buy something which won't work. That's the sort of thing that the trader may not always say. And equally, they might not always tell you about your right to withdraw if they've actually got one. They might try and hide it. Now, you might think, well, business buyers surely should ask for this. But if the trader is having to produce all this information anyway for consumers, what's the harm in saying, well, just produce it for everybody, just require it for everybody? It's no real restriction on the trader. It doesn't add very much to the costs. I equally think that it should be done in a clear and comprehensible manner. That requirement at the moment only applies to consumer contracts. Not a subject for today because it will take too long, but I can't see why on earth it shouldn't be extended to business contracts. So what should the new version of the CCIL cover? Well, clearly it should cover the main obligations of the seller. For example, the stuff that's contained in our sections 12 to 15 of the Sale of Goods Act 1979. You might think, well, surely that's the same in every country, but it isn't, particularly not for business-to-business contracts, nor for digital downloads. Most countries have no legislation on digital downloads. We're only getting it under the Consumer Rights Bill, which I hope is going to go through. But equally, even in consumer cases, there isn't the same provision everywhere, because some countries go in for gold plating, as indeed we do. The Consumer Rights Bill, for example, imposes a new term that if the consumer is shown a model of something, then the goods have to conform to the model. Now, I don't think it actually adds very much of substance, but it's going to be confusing for an overseas buyer, an overseas seller, who think, what have I got to comply with here? I don't really understand this. So I think we need to cover those primary obligations. We also need to cover the remedies for nonconformity, because across the member states there is still significant variation which can cause problems for businesses because they won't know what the law is in every member state. For example, some member states require that if the seller delivers goods which don't conform to the contract, the buyer must first of all ask for repair or replacement and can only terminate the contract or ask for a price reduction if the seller fails to repair or replace the goods. Whereas our system, of course, gives the consumer an immediate right to terminate. How long it goes on for, we don't know, but they have an immediate right to terminate. But even more fundamentally, we think of termination as being a useful remedy for consumers because consumers can simply notify the trader, I'm rejecting the goods, give me my money back. But there are quite a number of countries in the EU where termination is still a matter for the judge. You have to bring a judicial proceeding before you can terminate the contract, which of course makes it useless for consumers. So it seems to me that that needs to be covered. And when you get to business contracts, there's even more variation between the member states. So all the more need to cover that in the CCIL. And I think we also need to cover non-negotiated terms. The old CCIL followed very much the EU model. It imposed controls over any terms that were not individually negotiated and used more or less the standard test from the directive that The term is unfair if it causes a significant imbalance in the parties' rights and obligations arising under the contract to the detriment of the consumer, contrary to good faith and fair dealing. And it applied that test, or a slight variant of it, both to business to consumer and business to business. Now, it seems to me that that must be included in the CECL. First of all, because it's at the core of the EU protection of consumers. And the domestic law of business to consumer contracts is not fully harmonized on this point. But secondly, because I see this as core protection for SMEs, but it's not protection which exists in every law. Doesn't exist in our own law, for example. But I think it should be applicable for business to business contracts when one party is an SME and the parties have chosen. Now, actually, this question of unfair terms raises a bit of a problem, which I think is quite interesting when you try to think about how this is going to work in the context of internet trading. In the past, I've argued that that test of unfairness under the directive is partly substantive and partly procedural. I have argued that what you have to do is to show, first of all, that the clause causes a significant imbalance, in other words, is significantly disadvantageous to the consumer, and that the trader did not treat the consumer fairly in the sense that they didn't make it obvious. That would be the bit about being contrary to good faith. And the result would be that if the trader makes it quite clear to the consumer what's going on, if the term is really clear and prominent, then that might save a term which would otherwise be unacceptable. And I think that there's been some judicial acceptance of that. If you look at what Lord Justice Bingham said in the Interphoto case, he talks about good faith as requiring you to put your cards face up on the table. In other words, if you're open with the other party, that means you've satisfied the requirement of good faith. But let's think about this in the context of these mass contracts, these contracts which are going to be made over the internet by clicking on the trader's website. Well, the first point is, of course, there's not going to be any negotiation. But also, think about the complexity of what we're dealing with now. Many of the old cases on unfair terms, for example, under the Unfair Contract Terms Act of 1977 in England, were of relatively simple clauses, like Woodman and photo trade processing. It's one of those cases where if you take your film to be processed and they lose the film, all they have to give you is a new film. Now, you may think that clause is fair or unfair, but at least it's very easy to understand. Everybody knows what it means. But now let me ask you a question. How many of you have a mobile phone? Oh, come on, own up. Yeah, okay. And how many of you have read your mobile phone contract? Or even more, I bet nearly all of you have a copy of Word on your computer. How many of you have read your end-user license agreement? Well, I certainly haven't. I never read that stuff. I always click, yes, I agree to the terms and conditions. Nobody expects that stuff to be read because it's far too complicated. In other words, when we're talking about fairness, particularly in these internet contracts where masses of information is produced in very short order, we shouldn't assume that anything will be read unless the trader takes special steps to ensure that the consumer is agreeing to particular points, maybe line by line. And that's why I want to see this fairness test incorporated in the CECL, because this is exactly the line that the European Court of Justice seems to be taking. First of all, they're saying that an important element of the fairness test, this is from the opinion of Attorney General Cockott in a case called Aziz, she says it's very important to know whether the term is a surprising term, something which you would expect or something which would be unexpected. That's an important element. But the Court of Justice itself went much further. They say, first of all, in order to ascertain whether a term causes a significant imbalance, what you need to do is to compare the consumer's position to the position that they would have if the general law applied. If there's a difference, that's a significant imbalance. But good faith doesn't mean just that you tell the consumer what's going on. Good faith requires more than that. The national court must assess for those purposes whether the seller or supplier, dealing fairly and equitably with the consumer, could reasonably assume that the consumer would have agreed to such a term in individual contract negotiations. In other words, the trader is required to think, is this term acceptable to consumers? And if it isn't, they mustn't put it in their contract. In other words, laying your cards face up on the table may not be sufficient anymore. And it's very much the German line, but I have to say I think in this case the Germans may have it right. The German courts take the attitude, if one party arrogates to itself the power to decide what's going in the contract by drafting a standard form unilaterally, then it must, as a matter of good faith, take reasonable account of the other party's interests. And if it doesn't, the term is invalid. So it's certainly not going to be enough to clear a term that I've signed the contract or clicked a button or that I've been given reasonable notice. And if the trader wants to depart from the norm, then it should somehow make sure that I know by presenting me, for example, with a summary of the terms and getting me to indicate by a click button or something that I agree each major point. Because otherwise, traders should realize consumers are simply not going to read the contract, and nor are businesses. So I want to see this sort of test incorporated. Well, I think we could also go in for a certain amount of simplification, but I'm beginning to get short of time, so I'm going to skip over this bit and simply say that I want to talk about the policies and values that are involved here. Now, as far as business-to-consumer contracts are concerned, I actually think that there's very little substantive difference between what's in the Common European Sales Law and the overall level of protection that's available in the UK at the moment. Okay, there are some things which are omitted from the Common European Sales Law, so the consumers have slightly less protection, but there are other aspects of the CSL where the protection is slightly higher, so that overall it probably works out about equal. But there are very substantial differences when it comes to business. Now, I'm not suggesting that the Common European Sales Law is entirely civilian in its outlook. It's not. For example, it doesn't depend on the subjective will of the parties, as is the case in French law and German law to some extent. It goes much further, like in English law, to protecting the reasonable expectations of the parties. But when you look at the individual rules, the content of those rules is much closer, for example, to the BGB than it is to English law. English law, compared to the CSL, is highly individualistic. We have a very limited doctrine of mistake and no duty to disclose. We expect business-to-business parties to ask questions beforehand, to know what to ask and to ask the questions. We don't have any general doctrine of good faith, and we have only very limited controls over unfair terms. Only exemption clauses are controlled. Now, why the differences in attitude? Well, some of the explanations may be historical, but why have those differences persisted? There may be differences in philosophy, but why do those persist? I think it's more because we actually envisage a different role for the judge and for the court. In particular, English judges are very fond of saying it is not our job to rescue a party who has made an unwise contract. Our job is to hold the parties to the contract that they have made. And we're not going to add to the contract. If the parties want extra protection, they must bargain for it themselves, put in express terms of the contract. We're not going to do it for them. It's better that the parties plan before the event than that we do so after. And if the parties didn't plan this time, well, they'll know for next time, won't they? But that leads us to think about a rather different role for contract law. I think English law regularly recognizes that there is a distinction, a clear blue water between what the law requires and what the parties actually may have expected of each other as a matter of commercial expectation. We don't see contract law as laying down how you should behave to the other party. We see it simply as setting limits. I sometimes liken it to a football match. French and German law tell the players how to behave on the pitch. English law says, providing you stay on the pitch, you can do more or less anything you want, you choose. You've just got to stay on the pitch. And there's a certain amount of empirical evidence that businesses view the law differently. In English law, we're constantly told businesses don't cite the contract to each other because that's seen as inimical to a good commercial relationship. It will sour it immediately. Whereas the Germans say, oh yes, we have mutual contract reading sessions as a way of building trust. Beer and contract go together. And indeed, in English law, sometimes we seem to find the parties deliberately trying to make the contract as abstract as possible, for example, with entire agreement clauses, to say you don't need to think about anything outside the contract. Now, why do we do this? Well, I think it's because of the typical cases that come before our lawmaking courts, the higher courts. Most of the contract cases that come before the High Court, the Court of Appeal, and the Supreme Court in England are what I would call heavy commercial cases. They are mostly high-value contracts made between sophisticated parties, usually with legal advice. They're often repeat players who know what they have done before and are doing it again. And they're very often in fluctuating markets, where the real question is, who's going to bear the market loss? If the seller can hold the buyer to the contract, the buyer will bear the loss. If the buyer can avoid or terminate the contract, the seller will bear it. And in that sort of case, as the House of Lords pointed out in Bungie and Tradex, what really matters is not some sort of abstract concept of justice. It's that the parties should know where they stand. Otherwise, we're simply inviting more and more litigation. And when we come to trying to sell English law as a law for export, the law of choice for international contracts, we're even more hands-off. The Unfair Contract Terms Act doesn't apply. So it's very much a law of the jungle, if you like. Now, of course, there are counter-tendencies. Lord Hoffman has tried to make the law more receptive, if you like, to commercial expectations, more in line with commercial expectations. His literal meaning rule being abandoned, the way that he's prepared to correct what he calls obvious mistakes in the contract, possibly to imply terms more readily, and the recent assumption of responsibility qualification to the Hadley and Baxendale test. All those things seem to try to make the law fit the commercial context a little more closely. But it's worth observing that there is quite a lot of judicial opposition to each of those changes. Why? Because the judges think you are making the judge look at more of the commercial context. That means hearing more evidence, adding to the complexity of trials, adding to the costs. So it's really quite controversial. But I'm talking about SMEs. And it seems to me that this individualistic law is very suitable for the typical litigant in the English High Court, those heavy commercial people. But I'm not at all sure it's suitable for SMEs. SMEs are different. As I say, they're risk averse, and I think most SMEs would welcome the opportunity to opt for protection, for having controls over unfair terms, possibly having a duty of disclosure, possibly even having a general provision on good faith and fair dealing, at least where they've chosen that. And it seems to me that although the Common European Sales Law does not fit with the traditional values of English law, it does fit perfectly well with the commercial expectations of the parties. And if parties choose to use a law which comes closer to their commercial expectations, why should we stop them? And indeed, why should it only be allowed in cross-border contracts? Shouldn't it be allowed, if SMEs want to use it, even in domestic contracts? Now, of course, an SME that's dealing with a large business and would like this protection may find the large business saying, well, hold on, if I have to give you additional information, If my terms can suddenly be challenged, I'm going to face greater uncertainty. Even if my terms are ultimately upheld, there's going to be a period of delay because you're able to contest my terms. That's going to cost you. But if I'm right that SMEs are risk averse, choosing the CECL to give themselves more protection will be a little bit like buying insurance. Insurance, if you like, against contractual accidents. And I think they may be prepared to do that. But what I really hope is that large businesses will decide to use the CECL as a signal of their own reliability. Challenge our terms all you like. Our terms are fair. We always act in good faith. We are good European citizens. So I think that possibly that may be the way forward. Now, I'm not suggesting that the Common European Sales Law is the answer to everything. There will remain many problems about selling across borders. The biggest one, of course, being language. A website that wants to start selling across Europe is probably going to have its sales information in several different languages, and is probably going to have to be able to deal with complaints and warranty claims in different languages. That's going to be costly. There may be other issues about getting goods delivered, getting payment, and dispute resolution is more important than anything else. And actually, I think the work that's being done on ADR, alternative dispute resolution, and ODR, online dispute resolution, are probably more important than the CECL. But I think the CECL may help. And although the CECL is different to our law, I don't think that it's in any way inconsistent with our values. So I would hope that we might be able to support it. Thank you very much.